Copyright. If you're on the modern internet, especially if you're on YouTube and Twitch, you really can't avoid it. So I ended up reaching out because we had reacted to some things recently, and copyright came up, specifically in regards to Games Workshop. And this seems to be the landmark case in regards to precedent for copyright. I know I bring up things like Metallica Be Unfaith, specifically in regards to audio, music copyright, modernity. However, I have on authority that this is the case that is the landmark. So I figured let's look through this, let's analyze this. And let's learn a little bit more about copyright, especially in modernity, shall we?
Today we'll be discussing the key facts and findings of the case Reckitt and Colman Products Limited and Borden Incorporated, otherwise known as the Jif Lemon case. Reckitt and Colman Products had been selling lemon juice in the Jif Lemon containers since 1956. Borden Incorporated introduced their product to the UK market in 1985. Their product was also lemon juice, sold in a lemon-shaped container.
Okay.
Borden Incorporated made 3 different versions of the lemon-shaped container, all slightly different to the original Jif Lemon.
Right.
This appeal by Borden Incorporated sought to overturn the original trial judge's ruling of passing off in favour of Reckitt and Colman products. The law of passing off exists to protect unique products that cannot be trademarked.
Okay. So, I mean, that does offer protection. Let's say tomorrow you were to develop a product, a solution, if you will, to a problem, and it was very unique in its design. You want to be rewarded for it, right? I mean, this offers protections, right? If you say tomorrow made a TV that had an actual like hollow, like Star Wars R2D2 Leia hollow projector in it, right? You would want some sort of protection. That way nobody could just come in and be like, hi, yeah. Or if you developed a new battery tomorrow and this battery had a battery life expectancy of 30 days, 1 month before recharge, and you're using proprietary technology and your own research, it protects your investment into that. So that makes sense. I think that logically is a reasonable protection.
Means that no man may pass his goods off as those of another.
Okay.
This case decided that in order to rule in favour for a claim of passing off, Reckitt and Colman would need to establish 3 elements. Firstly, that the goods or services have acquired goodwill or reputation in the marketplace that differentiates their product from competitors.
Okay, so if you have, and I think we could argue the Mark 1, Mark 2, Mark 3, the lemons are going to be quote-unquote derivative, right? I think derivative would be the word. Specifically, if one company did the funny lemon, and Beckett and Colman did the funny lemon container, and then now you have derivatives of the lemon container, right? So I think at that point, you're looking at, okay, but does this actually, like, affect the core product, right? Like, can you copyright a lemon? I think is partially what this could come down to in the case. Yeah, so in regards to the first one of acquired goodwill reputation in the marketplace, are you clearly just a derivative work, or do you have a lemon container that is like, are you just derivative of the initial, the original Reckitt and Colman lemon? Are you derivative of that, and are you just kind of the quote-unquote knockoff, or are you actually your own product that actually has its own standing and merit, right? Product might confuse others. Are you advertising yourself as, if you have a Beckett, or sorry, I keep saying B, Reckitt and Colman lemon, right? You have that. Are you instead of a Jif lemon, are you a Joff, Jof lemon, right? Are you trying to be the Stephen He when everything's off-brand, those things? Are you trying to be that? Are you trying to skirt off of the success of what is being derived from, right? I think that's what this can allude to.
Secondly, that the defendant misrepresents his goods or services, either intentionally or unintentionally, so that the public may believe the product is the plaintiff's.
I think that's fair, though, because at the end of the day, if you're offering a product like Nintendo, let's say, I'm looking at my Nintendo Switch, it's what I have, right? And you have a Nintendo, M is in Mary, right? You have a Nintendo, right? And it looks kind of the same, right? Even though it's off-brand, like it's an attempt to confuse. It's an attempt to use a derivative work to try and capitalize off the success of the primary work, right? Like, you should have protections against that. If you make, I don't know, if you make a a kit bottle, right? Crystal Skull vodka status, right? Like if you make something like that and you're trying to protect, yeah, this is a vodka bottle in the shape of Kip's head with the horns and stuff, right? Sure, yeah, you should have some kind of protections for that versus somebody coming along and be like, it's a pretty neat idea. And I'm sure like there's dimensions that go into that. So like, sure, you have Dan Aykroyd's Crystal Skull vodka, but I'm sure that if you have like, you can't necessarily copyright a skull, but if it's the exact measurements of that skull or it's portrayed in a certain way, I'm sure then that runs afoul of, copyright.
And thirdly, that the plaintiff may suffer damages because
Right.
of this misrepresentation.
Makes sense.
With regards to the first element, the court held that Reckitt and Colman were unable to register a trademark on their packaging as it was shaped like a lemon, and
Right.
the law seeks to avoid giving one company a commercial monopoly over a natural item.
So there is an exception to this, and it's not as an exception as so much as there's a lot of nuance that goes into it. What is it, Sky News? It's because of how they're registered and they were grandfathered into it, but that's kind of it's not even an exception. It's a very specific interaction. And I've talked about it before, and I'm sorry that I don't remember the details. There is a interaction with Sky, but it's like you can't copyright like the color blue. You can't copyright monitor. You can't copyright rock, right? Like you can't copyright the broad thing. And I think this is actually I'm assuming how this relates to actual pop culture things, right? Warhammer 40K, did they not have a lawsuit where they allegedly tried to own the concept of a miniatures game? They tried to go do court over that. Well, how do you own a miniatures game? What about Little Green Army Men? What about other things that could utilize miniatures like D&D? Do you just own a monopoly on that? Probably not. And that's how this case will reflect on other modern elements. So it's interesting to see that this is the focal point, and I've been recommended this a lot, because this really does seem to cement that there's a lot of precedent that goes into this.
However, due to the UK market, Reckitt and Colman had a de facto monopoly, but not a legal monopoly over the sale of lemon juice in lemon-shaped containers.
Okay.
This monopoly and the wide brand recognition of the Jif lemon packaging was enough to convince the court of the strong reputation of the Jif brand in the marketplace. For the second element, as observed in Peyton and Company and Snelling, Lampard and Company, when a product uses distinctive features, even if they are common to the trade, if another person seeks to put goods on the market using the same distinctive features, he should take care that those goods can be really distinguished from the original. Lord
Right.
Oliver held.
Yeah, exactly. I was about to notice the Jif one. You notice how it's more like almond shaped. You notice that it's got the nub. It's more elongated. It's like if you like squeezed it in your hands, right? You took a ball and you squeezed it in your hands. How it has that oval shape kind of. Notice the features and notice how these are distinct shapes. You have the one on the right, which is clearly more obtuse. It is clearly more round, rotund, if you will. There is a legal distinction here. So like miniatures game, right? Where this is, let's not even do miniatures. Warhammer, Space Marine, Ultramarine specifically, versus what little I've seen of StarCraft 2's whatever they are, right? Sure, they're both big pauldron wearing space dudes, but like while the Space Marines have kind of like their helmets, their iconic helmets, right? It's like what the StarCraft ones have more of a like an astronaut helmet kind of thing. I'd have to look at their designs like next to each other, but once again, a real world pop culture example of, in my opinion, this in its full effect. It's not even like legally distinct, quote unquote. It's like, okay, what separates you from this other thing, right? What separates Mario from something like Crash Bandicoot? Oh, well, they're both platformers. They both have funny mechanics and stuff, okay. But like, the art style is clearly different on them, and there's different kinds of power-ups and stuff like that, right? What separates Call of Duty from Battlefield? I mean, there's mechanical things we can talk about, visual things we can talk about, and then you start getting into the concept of, well, if you're trying to model an M4A1, right, an AR, if you're trying to model that, I mean, do you need to make legally distinct AR? Do you need to make legally distinct M4A1? Or is it like, okay, but this is clearly what this work is? Now, you do run into issues with like copyright in regards to like Resident Evil 5, right? It just says S&W 500, Smith & Wesson 500. It's why I bought mine, because literal game, because it's funny. It's not the long-barreled version like I wanted, but it's close enough. Or like M92F, right? Clearly a Beretta, right? And then you'll have modern Call of Duty games where it's not a Vesper, it's a Fennec, right? Like, you start getting into copyright with that, because copyright does clearly exist for that. But even then, you could have like legally distinct, oh, well, that's a Vesper with a drum mag. Oh, isn't that just Lion from like Rainbow Six Siege, right? Like pop culture examples of this in effect, of having a distinctive product.
That as the labels on the bottles served no functional purpose and were generally thrown away, they were not sufficient to distinguish the real lemon bottles from the Jif bottles.
Yeah.
Furthermore, as a side-by-side comparison was not usually possible for shoppers, it was held that shoppers were likely to purchase real lemon juice, thinking it was Jif. Finally, it was held that the confusion amongst shoppers between the two products was likely to result in a loss of sales for Reckitt and Colman products.
Sure.
In conclusion, the court ruled that the common law wouldn't legalize a monopoly in an article itself.
Okay.
However, Reckitt and Colman was still successful in their claim for passing off.
So that's actually interesting, where even if it's a legally distinct thing, right? Because I thought this was resolved in a way that it was in Borden's favor. So it's actually in Reckitt and Coleman's in their favor, which is actually super interesting. Hence reacting to this live and learning about this case, right? I have very little prior knowledge to this. But even then, legally distinctive, it can, because then you start getting the idea of monopoly, and that's why people go, well, monopolies are fine, and well, Steam's a monopoly. No, Steam is not a monopoly. It just has the best user interface, and that's why people use it. It has a better user experience that is not a monopoly, because things like EA, Uplay, Epic, GOG are still allowed to exist. They're not effectively barred from the market. So they cannot legalize a monopoly on themselves. Futures would need to be a bit more distinctive. So I think it'd be interesting to understand how legally distinctive it would need to be, because there is a green cap here. I mean, you could argue it's inverted, right? Green cap, more rotund. So I think at that point, rather than trying to pass off as, cool, we are and lemon, right? Maybe you have more distinctive feature. Maybe make it in the shape of Danny DeVito's head. That's clearly a joke, right? But like clearly there needs to be a lot more distinctiveness to this. Okay.
Borden Incorporated were not restricted from selling juice in lemon-shaped containers.
Sure.
The containers just had to be made sufficiently distinguishable from the original Jif containers.
So what's the conclusion? What do they have to look like then?
Reckitt and Colman products was an essential case to the law of passing off because Lord Oliver's obiter was the first to discuss in detail the 3 elements required to satisfy a passing off claim. These judgments from the House of Lords are still used today to decide cases for passing off claims.
Well, and then that's the thing is, well, you could argue this is just the UK, but I mean, this stuff like this does have global implications as well. So I actually thoroughly enjoyed this presentation. I felt like I got to learn a lot with this presentation, even then, with the conclusion not necessarily being what I expected it to be. I thought it was really good, and I thought this is a good crash course in regards to passing off, in regards to the legal standing of how copyright works, and then you can definitely see how certain things are. Hey, isn't that StarCraft thing just a space marine? Well, no, it's really not. These are the differences X, Y, Z, right? And thus why you have things when they're too similar, why companies, entities, etc., individuals, etc., will look at things like this and they'll be like, okay, we might have a case versus this, because absolutely, like you don't, art especially is derivative, right? And you can do it in good faith, but you need to make sure that you're doing something different. I myself am reacting to a video that is derivative of the original presentation. Now, I would hope I would be transformative enough, making a 3-minute, 51-second video into an almost 14-minute video. But that being said, I mean, that's why we have pillars of usage. We have pillars. I think there's 4 specifically when it comes to content like this, content being derivative of other material. But this is interesting that it kind of, a lot of this copyright does link back to this case. And I think that it opens up a lot of doors and opens up a lot of questions. And you know what I say about the best question you can ask is why? Why is this case so important? Why does modern copyright, a lot of it go back to this? And I think that, why is this legally distinct? Why is this not legally distinct? I think there's a lot to it. And I really enjoyed this. So wanted to make sure I was able to kind of look at it. I'm going to kind of mull this over for a little bit. I thought this was an amazing presentation. Thank you to the individual who did send me this on authority that this is a pretty good breakdown of the situation. And this is definitely going to be something I'm going to be thinking about in regards to copyright in the future. I hope you enjoyed watching. Hopefully you learned something. Definitely check out the original channel, as I've linked down in the description, as well as the original video. And I'll see you in the next one.